Hello students, we were studying the topic Introduction to Companies Act and we have covered almost most of the topics under this, that is basics of company law, introduction to Companies Act, company definition and its characteristic, lifting of corporate. We were on types of company, so there are certain types of companies which were left, and so let's study further, and we'll start with a private company which is defined under section 2 clause 68 of the Companies Act, which means it's a very important thing. Okay, from amongst all definition, it is very important, so we need to study it very carefully. And also small company was very OPC was also very important. Okay, now what is section 2 clause 68 defines private company. It means a company which has minimum paid up capital as may be prescribed, minimum paid up share capital as may be prescribed. Now it's not yet prescribed. Earlier it was 1 lakh, but now this limitation has been removed. So with 2 rupees also, even 2 rupees also, you can incorporate a company. So why I'm saying 2 rupees? Because there must be at least 2 members. So at least 2 members is required. So every member need to contribute something to become the member of the company. So at least 1 rupee need to be invested by them to subscribe its share. So at least 2 rupees investment is required. Okay, but it's not a legally written somewhere, it's just an interpretation. So it means a private company means a company having minimum paid up share capital as may prescribed, and which by its article in the articles of association of the company, means there is a memorandum which I had already discussed, and after that there is an article thing. What do you mean by article? Memorandum is basically comes under Companies Act, means all the provision of Companies Act and the things, the right, the objects of the company, the liability, the registered office of the company, all these details are being given under memorandum. But what articles do? Article provides the things that company can do and company cannot do, and how the provisions that is given under memorandum need to be complied by the companies written in article. We'll study this in detail in further classes, and in this for your understanding purpose you should know that in a private company, to form a private company, in its article it must write at least these some 3 restrictions in its article, and then only that particular company will be considered as article as private company, as if such that as when such company has these restrictions on its articles. Okay. Now, what is the first restriction? It restricts the right to transfer its shares. Okay, so the private company cannot freely transfer the shares of a private company. That is, any member of private company cannot freely transfer the shares of private company. There are certain procedure that is to be followed, and the procedure is that you need to pass board resolution. First of all, you need to offer these shares to the members who are there in the company, and if these members denies with to subscribe these shares, then if they allow you, then only you can offer these shares to an outsider. Otherwise, you cannot freely publicly transfer the shares of private company. And except in case, second restriction is except in case of OPC, because we have said in OPC there is only a single member, not minimum, no maximum, only one member is there. So except in case of OPC, in any other private company, they had assigned the maximum limit for the number of member to 200. Okay. Now, but there are certain provisions for that, means certain exception. First exception is provided that, again you can remember the word we had studied, provided that where two or more person who hold one or more share in a company jointly, or they shall for the purpose of this clause will be treated as single member. Means if two or more person like this, two person hold 10 shares collectively, and this share certificate has name A and B both in it. So this particular share holder will be considered as one member because they held this share jointly. Okay, this is what it's written. Provided that where two or more person hold one or more shares in a company jointly, they shall for the purpose of this clause will be treated as single member. That is, if there are 200 members, suppose 199 member, and this one is these. So these two will be considered as one member. So it will be 200, not 201. Okay. Now, provided further that a person who are in employment of the company, means person who are the employees of the company. You can write in here who are the employees of the company and the member of the company will not be included in this count of 200. Okay, these all exception is for the count of 200. So in the calculation of 200, these two person will be taken as one, two or more. Okay, and the employees will not be counted who are the member, and those person who having been formally in the employment, means they were previously employed by the company and they were the members of the company while they were in employment, and they have continued to be the member of the company even after the employment cease, shall not be included in the number of member count. Okay, what does it mean? That and Mr. X, he was the employee of the company and the member of the company, and now the today's scene is he is not employee of the company but he is still the member of the company. So again, still also he will be not counted in this 200 calculation. So this is only written here. Then third is, it prohibits any, this is the third restriction. What it says, it prohibits any invitation to public to subscribe for any securities of the company. That is, a company, the private company cannot issue its any kind of security to public. That is, you would have never seen any private company to get listed on stock exchange. To become listed, a company must first itself need to convert itself as a public company and then it can get listed. So because of this third restriction. So because of this third restriction, you can say you have this first restriction. Okay, इसकी वजह से ये वाली restriction है. Because you cannot give invitation to the public, you have restriction to transfer your shares. Okay, let me clear this. You can note this if you want. It's not that proper, but you can. Okay. By pausing the video, I'm erasing this. Okay, take the screenshot once again. I hope you have taken. I'll just rub it off now. Now, this, you can note this also. Pause the video and note it. Okay. Now, we'll have this. One second. Now, continue with public company part. What is public company? It is defined in the section 2, clause 71. Now, if you have understood what is private company, then this will be very easy for you. And if not, then first again reverse the video and watch what is the private company and then come forward here. So what is a private company? According to section 2 clause 71 of Companies Act 2013, a public company means a company which is not a private company. Private company means a company which has those three restrictions under their articles. Okay, so it says that a company which does not have those three restrictions in its article will be considered as a public company. Okay, and has minimum paid up share capital as may be prescribed. So from here also the limit has been removed. Earlier it was 5 lakh. Okay, and 7 or more members are required to form the company. So if we talk about members, you need to have at least 7. Directors, you should have at least 3. And for private company, you have members at least 2. For directors, you should have at least 2. But for public company, members at least 7 or directors at least 7. At least 3, sorry. And maximum limit of director is 15 for all companies. Okay. And here maximum limit is 200 members. Here it is infinite. Now you can note this. Okay. Now, provided that a company which is a subsidiary of a public company which is not being a private company, means a company which is subsidiary of a company which is not a private company. So a company which is not a private company is a public company. We had already seen this in definition. Such company shall deem to be a public company. So what do you mean by subsidiary company? We'll be going to know in the for the slides. So what I'm trying to say, and private company which is subsidiary of public company, a private company which is subsidiary of public company will deemed to be the public company. That is, we'll consider that this private company as a public company for the purpose of this act, and such company has to comply with all the provision of Companies Act as if it is a public company, and even where such subsidiary company continues to be a private company in its article, but still Companies Act will consider that company as a private company. Now, small company. Section 2 clause 85 defines small company. Now, it is also a kind of private company. Okay, note that. Now, according to section 2 clause 85, a small company means a company other than a public company. That is, it is a private company. But there are certain changes. That's why it's named as small company. It means a company whose paid up share capital does not exceed 50 lakh or such higher amount as may be prescribed, which shall not be more than 10 crore rupees. What this means that, one second. Means a company whose paid up share capital does not exceed 50 lakh rupees or such higher amount, means or such higher amount as may prescribe, means that in rules they can prescribe later on some higher number than 50 lakh, but again they had put some condition that such higher amount will also will never be more than 10 crore rupees. Okay, means they can raise the limit to 1 crore, 2 crore, 3 crore, but they can never raise the limit to 10 crore. But as of now, the paid up capital which shall not exceed 50 lakh rupees. Okay. But when you're going to write this in examination, you have to write it completely. That is, according to section 2 clause 85 of Companies Act 2013, a small company means a company other than a public company whose paid up share capital does not exceed 50 lakh rupees or such higher amount as may prescribe, which shall not be more than 10 rupees. Or second condition is here word or is mentioned, means either paid up capital or turnover, if any of it get increased to the threshold limit which is written here, then such company will not be considered as a small company. To consider it as a small company, its paid up capital should not be more than 50 lakh. Its turnover should not exceed 2 crore rupees. Okay. Or such higher amount in similar way it is written on, or such higher amount as may be prescribed, which shall not be more than 100 crore rupees. So provided that nothing in this clause, means this small company के जो provision है, the provision of small company shall not be applicable to holding company or subsidiary company or a company which is registered under section 8. This is a non-profit company, you can write it here. Okay, this section 8 company is a non-profit company, NGO kind of thing, but this is particularly registered under this act, this particular section, and a company or body corporate which is governed by special act. These three kinds of company will never be considered as small company. Okay. Now, what are the advantages of a small company? First is you have to hold only 2 board meetings in a year. Otherwise, you need to conduct at least 4 board meetings in a year, and there should be a gap of 120 days between 2 board meetings generally. But for small company, the provision says that gap should not be more than 90 days between 2 consecutive board meetings. That is, between 2 consecutive board meetings, it should be held as such that this gap between 2 board meetings should not go beyond 90 days. Okay. Now, not required to give cash flow statement with the financial statement. Okay. So small companies also not need to give any cash flow statement. Okay, with financial statement. Only financial statement is more than sufficient for them. Now, the most important thing that has come is holding company and subsidiary company. So, to understand it better, first of all, I want to tell you about the subsidiary company, and then we'll be talking about holding company. So, what is subsidiary company? Section 2, clause 87 defines subsidiary company. It says, in relation to any other subsidiary company in relation to any other body corporate, which is to say, holding company means a body corporate in which the holding company controls the composition of board of director or exercises the control more than half of the total voting power, either on its own or together with one or more subsidiary company. What does it mean? That is, this is a holding company and this is a subsidiary company. How this company becomes a subsidiary? Either this company holds the composition of the board of directors, that is whenever the directors are being appointed or reappointed, we take the permission of this holding company, or more than half of the total voting power. Share capital also I can say, but share capital with voting rights. So if such kind of shares or securities is being subscribed by holding company, which is more than half, that is at least 51%. At least 51% is being held by holding company of subsidiary company, then this other company will be called as subsidiary company. And it is not necessary that 51% need to be held all together by holding company. It can be acquired by 2 or more companies, like a group company or a holding company who has a subsidiary company. And if such subsidiary company purchase 51% shares or voting rights in S2 company, then for this S2 company also, this company will become holding company. Okay. This company is will be holding company legally, but this company will also be the holding company for S2. This is what it has been given under, either as its own or together with one or more subsidiaries. So there is some provision. It is written here that such class or classes of company, holding company, as may prescribed, shall not have layers of subsidiaries beyond such number as may be prescribed. So it should not be more than 2 layers. That is, it cannot go beyond this. Only this is the limit up to which this holding company can go. Okay. So what does it mean by holding company? Holding company is defined under section 2 clause 46. It says holding company in relation to one or more company means a body corporate of which such companies are subsidiary. Means a body corporate for which such companies, that is S1, S2, are the subsidiary company. Okay. Now, on the basis of listed, I had already explained you this. Listed company is defined under section 2 clause 52, which says listed company means a company which is listed on recognized stock exchange, and unlisted means a company other than the listed company. Now, other types of companies, there is government company. Government company means a company in which not less than 51% of the paid up share capital is held by central government or by any state government or governments. Governments means by one or more state governments altogether hold not less than 51% paid up share capital in such company, and or such 51%, not less than 51% of paid up share capital is partly held by central government and partly by one or more state government, and it includes a company which is subsidiary of government company. Okay, and such company can be both private company or public company, as the case may be. Okay. No, but generally it is a public company because it has more than. Generally it is a public company. Okay. So I had already told you no company will go beyond these 2 criteria. Okay. But individually it is a government company because government holding is there in this company. Now next is foreign company. It is very important and you have a different chapter for this also. So generally definition is given under section 2 clause 42. It's an important section. Please remember the section also. It means a foreign company means a company or body corporate which is incorporated outside India, and means a company which is not incorporated in India under Companies Act. It is incorporated outside India, but it has a place of business in India, whether by itself or through an agent, physically or electronically, and it conducts any business activity in India in any other manner. That is, both the condition need to be followed as end word is given here. So it has to have a place of business in India and it must conduct any business activity in India. The next definition is associate company. It is also very important one. Okay. Section 2 clause 6 define associate company. It says associate company in relation to another company means a company in which the other company has a significant influence. This is the very important word in this. Means a company in relation to another company means for this X Limited and Y Limited. So this is, let this be the associate company for this. How it will be? So it means in relation to another company, that is this. A company in which that other company, that is X company, has a significant influence. How the significant influence will be there? It means a control of at least 25% of total share capital or business decision under an agreement. So at least 25% share is being held by X Limited in Y Limited, or it controls a business decision via any agreement, joint venture agreement or any other agreement, strategic alliance agreement or any something like that. So for X Limited, Y Limited will be his associate company. Okay, but such company is not a subsidiary company, mind it, because you hold only 20%, not 25, it's 20%, sorry. You hold only 20% stake in the company, not 51%, not more than half of the percent. Okay, so you are not a subsidiary company, it is only a associate company. And it also includes a joint venture. I had already said. Associate company in relation to any other company means associate company in relation to other company, that is X Limited, means a company in which X Limited, that is other company, has a significant influence, but which is not a subsidiary company of the company having such influence, and includes a joint venture company. As per explanation, significant influence means a control of at least 20% of total share capital, or may affect the business decision via any agreement, that is joint venture. Now, Nidhi company. Nidhi company means a company which is incorporated as a Nidhi, where the main object is they basically collect the savings from the members of that company, okay, and among they take the deposit, receives a deposit from those members and lend to those the members amongst them who are in need of it, okay, and they may charge some interest for the mutual benefit. So they do not lend any money to outsider, okay. So the main objective is for cultivating, that is developing the habit of thrift, that is cost cutting and saving amongst its members and receiving deposits from them and lending to the members only. Means nothing will go beyond the members. It is given under section 406 of Companies Act. Now, this is also very important section, dormant company. Dormant company means a company which is formed and registered under Companies Act 2013 for a future project or to hold an asset or IPR, intellectual property, and has no significant accounting transaction. Such company or an inactive company may make an application. Such company means a company which is registered like this, or a company which is inactive company, means which does not have any significant account transaction, may make an application to ROC, that is registrar, in a manner as may be prescribed to get the status of dormant company. So what it says, a company may be registered from the beginning itself as a dormant company because it is just incorporating the company for any future project which is not yet started. That is, if you have any technology, or if you have to do any open any factory for construction purpose, so till the factory is being built, till that time you can get the status of dormant company, by which you will, because you have no significant transaction, or if a company is there, you have own a company but it is not working, you don't have any significant accounting transaction, then you may make an application to ROC to get the status of dormant company. Now, what is significant accounting transaction? It means any transaction other than payment of fees by a company to registrar. Okay, it means if you pay any fees to ROC, it will be not considered as accounting transaction, significant accounting transaction, or you are just giving any payment to fulfill the requirement of any law, or you are allotting shares to fulfill the requirement of the act, or for the maintenance of the office and records. So for these particular things, if any transaction occurs, it will not be considered as significant accounting transaction. Okay. Now, PFI. It is also being defined under section under Companies Act under section 2 clause 72. The following institutions are to be regarded as PFI, that is LIC, established under LIC Act, Infrastructure Development Finance Company Limited, UTI, and institution notified by central government. Okay, and these and such other institutions as notified by central government in consultation with RBI, provided that no institution shall be so notified unless it is established by center or state and having not less than 51% of paid-up share capital held by central government or state government, means unless it is a government company. So mostly consider that this is either it is to be established by center or state, or the holding is major holding is with government. Then only such institution will be considered as public financial institution. Okay, nothing to explain in this. Now, last topic of the day is illegal association, that is section 464 of the Companies Act. What it says: no association, partnership which has more than 50 members will be considered to be carried out. Means legally, if any partnership firm or any association of person in which there are more than 50 members and which are carrying out its business with an object to gain profit, object to acquire the profit, then such kind of association or partnership firm will be called as illegal association. Such association or partnership firm needs to get registered in under Companies Act compulsorily. But this above provision, above section will not be applicable to HUF or an association or partnership firm which is formed by professional like CA, CS, CMA, who are governed by special acts. And every member of association or partnership firm carrying on business in contravention to above law will be punishable with fine of 1 lakh rupees and will be personally liable for all the liabilities which is handled in the business. And such association will be called as illegal association, and such a body will have no legal existence and it cannot be wound up under the Act or even as an unregistered company, and neither the member of the company would be sue it or would it be able to sue the members. Means anyone who is victim of the of that particular illegal association can directly sue to the members of that particular association and not to the company. Now, every person who is or continue to be the member of the association in the circumstances described above is personally liable for all the liabilities incurred in such business, in addition to the punishment that we had already discussed. All the members of that association will be personally liable. Thank you, and please revise and ask your query regarding this particular topic, if any. From the next topic, we're going to start with formation of company. Till then, thank you. Bye bye.